let's begin. So just to kind of, well, first of all, I'm going to ask my standard 2 questions. Okay. I put a lot, I dedicate a lot of time and effort to these webinars. It takes, a lot of my time. I am getting more busy. I think some people didn't realize that I don't just teach, I also represent. And so my law firm side of the house is actually increased tremendously. A lot of it because of these webinars, which is great. I love representing officers and agencies for various things. So just remember, you should keep my number if you need, now you have your reps, your union reps and so forth. But if you need to bring out outside help because you're getting in trouble at work, or, you're getting days on the beach or reprimands or whatever, you can call me, and I work with the unions and so forth where I have union rates. So my point is like, if you need somebody like me with my specialty, contact me and we can talk business. But that side of the house has increased. I love doing it. Zoom has made it a lot easier to represent cops around the country. And so it motivates me. I've been representing cops for years. Even when I was a police officer, I was part of the association representing cops and so forth. So there's that. So spread the word. If you like these webinars, I'll keep doing them. As long as, we have enough people showing up, I'll be here. Also, take the full day class or take the on-demand training. The on-demand training is great. And right now, the cost is extremely low to get you guys in the door, but it's going to increase dramatically. I mean, it's just very low right now just because, again, Corona and everything going on. Yeah. So Kyle actually just purchased what I call the ultimate package. Kyle got a freaking smoking deal. He paid one price, and Kyle is going to have lifetime access to everything I put on the, right? Yeah, Kyle, you're going to get access to everything I put on the future too. So you're an early adopter, but that program is probably going to be twice as much soon. It's just but congratulations. You're going to have a career time of search and seizure training for that one price. So that's smoking deal. So if you guys are interested in that on-demand stuff, go to ondemand.bluetogold.com. ondemand.bluetogold.com. I'll just type it in here. Okay, let's get started. So remember to select all panelists and all attendees, okay? Also, while I'm giving my little speech, please give a shout out of where you're from. I want every single person on this webinar to please share your agency with your fellow officers, because that's part of the fun. Thanks, Mark, and make sure that you send it to all. Mark, are you related to the former sheriff? Isn't that the former sheriff's name? I think, right? So to all attendees, just like that. Right, okay. All right, so cool. What's up, Jason and Kyle from Pacific County, Kyle from Pacific County, and Jason from New Jersey. Right on. Okay. Now, Anthony and Adam, resend that out to all attendees, please. The 2 Anthonys, all attendees, because nobody can see it. So please, Anthony from New Mexico and Anthony from California, please resend that out. And also Adam from Orange County, please. Resend that to all attendees. Thanks, buddy. Okay. So my name is Anthony Bandiero. I'm an attorney and search and seizure expert. There we go. Now we're talking. We got our first question. So this is what I do for a living. I have the honor and the privilege to train police officers from around the country and represent. So I also have 2 books. If you do not have these 2 books, Cole, do me a favor, resend it out to everybody. Lauren, same thing, please. Lauren and Cole, resend it out or cut and paste it to all attendees, please. And welcome here, guys. Welcome. So I have 2 books. These 2 books are vital, right? Actually, and there's a 3rd book, but these are the 2 books that I wrote. These books are vital for your education. They summarize case law in a very cop-friendly manner, right? Short, sweet, to the point. You guys are going to love it. The report writing book is brand new. There is a course. What's up, Justin? There is a course that goes along with it. I'm teaching that course for the first time in Denton, Texas. Actually, I think I'm teaching in Surprise, Arizona, too, this month. So I'm very excited about that. It's a brand new course called Bulletproof Report Writing. It's not your stereotypical report writing class, which is all about grammar and punctuation and so forth. It's a small piece of that, but the bigger piece is helping cops to articulate those things they need to win their cases. So go to the website, bluetogold.com, and you can see the books there. They're on sale as well, free shipping. You're going to love them. Disclaimers. Laws and agency SOPs may be more restrictive, right? Laws and agency SOPs more restrictive. I teach at the national standard here. Now, I'm also really good at New Jersey case law. So if you have a New Jersey case law question, you can ask me. And I teach other places too, but my point is if I don't know that you're from a particular state, I'll just give you the Fourth Amendment answer. If you have any doubts about the legality of your actions, push up the chain. And finally, this course is legal education, not legal advice. This is education. This is just my opinion. This is like a talk show. You want my opinion? I'll give it to you. But what's it worth? 2 cents. It's my 2 cents. If you need legal advice means that if you want me to research your question, well, you have to hire me. But my point is that takes hours and hours to find the legal cases and so forth. But that's what the difference is from an attorney opinion, a legal opinion, and a personal opinion is legal opinions are backed up with case law and laws. Okay, to get your certificate, download it from this website, bluetogold.com/cert. Look for Search and Seizure Saturdays, download it. It's a fill in the blank. That's what you're going to need. You can print it, save it as a PDF, and so forth. Okay, your questions. All right, so the first question I have came from an officer, but it only got sent to me, so I'm going to resend it out to everybody. I'm going to keep the officer's name out of it because I don't know if he or she wants me to put his name on it, but that's the question. All right, now I got to read it, and let's answer it. So I was recently was called to a disturbance call where a subject was said to have paraphernalia and or drugs. He invited us into his apartment to speak with him. 3 of us entered but left in an unobstructed way for him to exit if he wished. He gave consent to search his room, but not the backpack he was wearing. It was non-confrontational encounter, and he was asked about 3 times to search his backpack, and finally he said fine, took off the backpack and reached in the front pocket and pulled out 2 grams of meth. I love it. So funny, man. All right. Can he say he was being coerced into giving up the drugs or consenting to the search? Well, of course, he can always make that argument. Okay, he can always make that argument. So here's what the law is going to require. The law requires 2 things for a search, for a consensual search. One is, step 1 is the consent free and voluntary? In other words, did the person reasonably have a choice in the matter, or were they coerced into giving the consent? And the second thing is whether or not the search conducted was within the implied or expressed limitations. So the person says, yeah, you can search my room, but not my backpack. So what we're looking at here, and I don't really have enough facts to make this determination, because I do have some questions on it. It's not a slam dunk, probably either way, but there are some concerns here. Okay, the person was asked, multiple times for consent. Now, that is not prohibited in and of itself. Officers can ask for consent, and the person says, okay, that's even better. Now, so, okay, so the extra added comment here is that there was a meth pipe in plain view on top of the dresser. Now, this is his apartment, right? This is his apartment. Okay, right. So here's the deal. Now you actually, what state are you in, by the way? Just out of curiosity. Okay. So California. So you're probably going to win your case no matter what. So to finish off with consent, and I hope that you guys, while we're talking about this, you are thinking of other questions to ask me. That's really what I want these search and seizure Saturdays to be all about. And we have up to an hour. We don't have to take the whole hour, but I want to answer these questions. So what I would like to see, if you have body cams and so forth, or in the report, is that it was kind of casual. It wasn't very aggressive. In other words, oh, you don't want to, if you ask for consent to search and the guy says no, but you follow up and say, oh, why not? I mean, if you got nothing to hide, you got to be careful though. I mean, it's just, I want to see what the cops say. I also want to see how they say it. So I don't have enough facts to make the determination. Right. Let me make sure. Okay, that's what was said. Let me just repeat it. Oh, it was not non-confrontational encounter, and he was asked about 3 times to search his backpack, and finally, well, I don't know. It seems a little dicey to me, to be honest with you. I think it's kind of pushing it, because it seems like the officers, the way it comes off to me is that the officers are continuously asking him for at least a total, 3 times total. I don't know. I think I can see courts going either way. I personally, based off of these facts, if I was the judge, I would not suppress it. But the good news is, you're not going to, the cops is not going to lose anyway, because of the search incident to arrest exception. Oh, wait a minute. Is a meth pipe an arrestable offense? Is a meth pipe an arrestable offense in California? Probably not. Well, it's still not going to matter. It's an arrestable offense. Okay, good. So actually, I was going to say it wouldn't matter anyway, because it wouldn't, even if it's citation only, it's not going to matter in California, because California abides by the Supreme Court precedents on this issue, which is the Supreme Court's called the City of Lago Vista, I believe, where the Supreme Court said that as long as you have probable cause for any arrest, even if it's a non-arrestable offense in your state, it still complies with the Fourth Amendment, and therefore you have this search incident to arrest exception. So no matter what, it comes in. So you have probable cause that he's committed an offense in your presence, a misdemeanor in your presence, right? The meth pipe, that's at least constructive possession. So therefore, even if you arrested him, which if you arrested him, even though it's a citation only, you arrested him and you found the drugs, inevitable discovery, in his backpack, it's coming in anyway. So there you go. So it gives, Brian says it gives PC that there were also drugs present. Well, that, and it also gives you PC to arrest the guy. So the best way to handle this legal argument is as a search incident to arrest exception. But Anthony, we searched, even if we searched him first, or even if it was coerced, right? Even if that was coerced, and we basically demanded that he, in other words, legally, it's the same thing as demanding that he provide, the contents in his backpack. But we didn't arrest him or even cite him until afterwards. right? Well, if you look at the book, the U.S. Supreme Court does not require that the arrest happen formally first. The search can happen before the arrest as long as you have probable cause to actually arrest the guy. So either way, I think you win, but it is a little dicey, and I would like to see a little bit more articulation, specifically what happened in that report, because the constant repeating, "Can I search your backpack? Can I search your backpack?" is pushing it legally. Okay, if the backpack was off in the room, he could have said search with the limitations, yes. So basically, he could have said, "You can search the place, but not my backpack." That's correct. In fact, that's what he said originally. He said, "You cannot search. You can search the room, but you can't search my backpack." So he did set, and it was on his person. But whether it's on his person or it's in the apartment somewhere, he can always set those limitations. So now the question is, okay, so question on warrant. Okay, so anyway, there you go. I hope I added some clarity. Okay, I hope I added some clarity. Okay, let's go to Kyle's question. This is like caller number 2, right? Question on warrant arrests. You're welcome, Justin. And I wish I had more of a clear answer for that consent issue, but it is a little dicey. Okay, one of the prosecutors is instructing us to search a suspect who has an outstanding warrant prior to warrant confirmation. I've yet to find case law that supports that. Doesn't the warrant have to be confirmed prior to a full search? Not really. I mean, not really. At the end of the day, there's a fair probability he's wanted, even if the warrant is not confirmed. So just to give you like an example of this, imagine that somebody has a warrant. Now they have a warrant because you have a wanted sheet on them, whatever. But the computer goes down, and dispatch is not able to confirm that warrant. Could you still take that person to jail? The answer is constitutionally, the answer is yes. Right. So the answer is yes. Now, what we teach and what I teach is to not arrest the person unless you have a confirmation, right? Unless you have confirmation. But constitutionally, you have probable cause to arrest, even if it's not confirmed. All right. Okay, Brandon asks, if you perform a traffic stop and the driver is unlicensed, is that enough to search the vehicle? Absolutely not, right? That's clear. There is no exception here that's going to get us into that car unless you arrest him, right? Now, Brandon, if you arrest him, then back up. Sorry, I'm mixing apples and oranges here. And what I'm trying to say is if you arrest him, you possibly have an inventory exception, right? But there is no other way to get into that car with that evidence. There is no evidence of an unlicensed driver. So the answer is no. So Brian says, if you arrest and tow, then you need to perform an inventory, but that's not a search. Since we are talking about it, yes, it is a search. It's absolutely a search, right? So, and the reason I say that is because some officers do say that, and they say that on the stand, and they shouldn't say that. They shouldn't dodge the issue about whether inventories are searches. They are searches, right? So here's why. Does an inventory fall under the Fourth Amendment? Yes or no? Right? Does that inventory fall under the direction and control of the Fourth Amendment? Yes or no? Okay, good. So the Fourth Amendment only regulates two issues, a search or a seizure. So if an inventory falls under the Fourth Amendment, which it does, as you guys know, then it has to be either a search or a seizure. So it's a search, but it's a category of search. And by the way, Brian, I know what you're saying. You're saying it's not a search for evidence, which is exactly what you're saying. But I do want officers to say that it's a search, but not for evidence. It's a search for community, right? It's a search for community caretaking purposes, for items that are dangerous, valuable items to inventory, and so forth. So there's a community caretaking rationale, but they are searches under the Fourth Amendment. Right. So we're on the same page, but just they are searches. And okay, what other questions you guys have? So I'm going to teach you a concept while you're getting your questions together. Hopefully you have more questions, but I did bring something in. All right, here we go. So can you go into search incident to arrest with the immediate area of a vehicle when an occupant is arrested? Yes, I can. So again, this is the book, okay? So let me just kind of bring up what the book says, and I'm going to just how the book can be used, okay? So involving vehicles. All right. So on page 112, for example, searching a vehicle incident to arrest. I feel like we're reading from the Bible here. Anthony, chapter 3, verse 5, you know? Okay. So searching a vehicle incident arrest. So when a suspect is arrested and unsecured, right? Arrested and unsecured, his vehicle may be searched if the suspect is within lunge area, and you reasonably the suspect may gain access to the vehicle, and you can search for weapons, evidence, and so forth. But here's the problem. Here's the problem. How many times do you arrest somebody and leave them next to the vehicle? Unrestrained. Unrestrained. Almost never. Right? Almost never. So that's the problem with that search. This is handled by Arizona versus Gant, right? Arizona versus Gant. So, and by the way, the Supreme Court in that case made a little footnote. They made a little footnote. They said that officers should not try to find a loophole by purposely keeping the unrestrained suspect near the vehicle in order to search. In other words, it would be very inappropriate to arrest somebody for a warrant. Have, let's say, 2 officers on scene. Keep the person out of handcuffs, but keep them near the vehicle. Have your partner watch them while you search the lunge area of the vehicle, hoping to find something. That would be extremely inappropriate, and the evidence will be suppressed. So, when a suspect is arrested and secured, right, which is the common theme here, you're under arrest, you put him in mechanical restraints, his vehicle may be searched if you have a reason to believe evidence of the crime at issue that he's being charged for is inside the vehicle. So if you arrest somebody for DUI and you put him in the back of the car in handcuffs, can you justify, can you articulate searching the car for DUI related evidence? Yes or no? Right. Kyle says yes. Okay. That's correct. No. Brian, no. Fortunately, that's not the law. So it's not within their wingspan. So first of all, that wingspan rule is actually misconstrued. Okay. So first of all, we're mixing up some when officers say wingspans, we get that because officers are mixing up a few of the doctrines. Okay. The wingspan rule comes from a case called Chimmel. Okay, U.S. Supreme Court called Chimmel. Chimmel talks about when you arrest somebody, you get to search their wings. They call it lunge area, reaching distance, wingspan area. It's all the same thing. So that is where that comes from. right? The wingspan comes from Chimmel, which is based off of incident to arrest. Then in a case called Belton in the late 1970s, the U.S. Supreme Court said that the wingspan rule also applies to vehicles, so that when you are arrested from a vehicle, you're allowed to search the wingspan area as a search incident to arrest. Then in 2009, Arizona versus Gant restricted and kind of overruled the Belton interpretation, which is, if you guys have been working for a while, if you worked prior to Arizona v. Gant, 2009, there's a very good chance that when you arrested somebody from a vehicle and they're in the back of your patrol car, you would go up to their car and search it almost every single time. Because of the interpretation, the good old days, that's right. I remember those days. I started law enforcement. Well, I started as a reserve in Massachusetts in 1999. I then became a full-time trooper in 2005. So from 2005 to 2009, I was searching cars routinely after arresting somebody, as Kyle says, the good old days. So Gant took away that exception. So now they gave us a reason to believe, which is lower than probable cause, okay? A reason to believe is lower than probable cause. But that's not it. They did not put the restriction in there of lunge area. It's what Gregory said, right? It's what Gregory said. It's where could you find evidence for this crime, right? They don't have a restriction necessarily. Now, can you search the glove box? I'm sorry. Can you search the engine compartment for DUI evidence? I would say no. I don't think you're getting into the engine compartment. Can you search the trunk? I say yes. I think I would, if I'm a cop on scene, because do I believe, is there a reason to believe that the evidence of the crime could be in the trunk? In other words, is it possible that why they went to their friend's house or whatever and they got drunk, that they actually have alcohol that they consumed before they started driving in the trunk? Is it a reason to believe that there could be alcohol in the trunk, which is the source of their intoxication? Yes or no? So that's what I'm saying to the court, right? I mean, a lot of people drink alcohol before they get into the car and do not want the cops to see it, so they'll put it into the trunk. But if they get arrested for DUI, that is very good evidence that they were drinking, and so forth, that it's not something else going on like a diabetic shock or something, that's evidence that you can take pictures of and put into your report that you found a vodka bottle. So the answer is yes. But you do not go to court, okay? Do not go to court and say it's automatic. I automatically get the trunk and so forth. That's not good reasoning. It's all about articulation, which if you have my book, is here. Okay. So I'm having difficulty understanding the Terry pat-downs. What type of situations warrant a Terry pat-down when consent is not given? So I'm going to answer that in a second, just to make sure. Right. And Kyle says, because we can't answer is what ruined it for us all. Kyle, are you talking about just in particular? Are you talking about Arizona versus Gant as well? Correct. Kyle, are you an attorney? Oh, so that's pretty astute of you. That's pretty badass that you remember that, because that's exactly what happened in Arizona versus Gant. The officer on the stand was asked by the defense counsel, why did you search my client's car? And he said, because the law says I can. Don't do that. Even if it was true to some degree. I mean, the officer is actually not wrong, literally, but it's just not what's required on the Fourth Amendment. The Fourth Amendment requires articulation. Okay. So let's go to Let's go to Adam's question, which is a very good question. It's an absolutely good question. So, first of all, let me bring out the scripture. I'm sorry. I'm sorry. I always worry about making those jokes because one day I'm gonna have like a really super religious cop on my webinar, and he or she's gonna smack me around a little bit, saying don't use the Lord's name in vain, something like that. But I'm sorry. I still think it's kind of funny because I do kind of feel like I preach sometimes. Pastor Anthony. All right. So pat downs. All right, pat downs for weapons. Scripture 63. hey, I'm gonna pass the I'm gonna pass the hat. Hey, is my Harvard guy here today, by the way? Jose or Lazaro. I promised him I'll show my Harvard hat. He's always been busting my chops. All right, pat down for weapons, page 63. All right. So here's the legal standard. You know, you can't really see shit, but it's not that great of a camera in that sense. Okay, but here's what I say, okay? A suspect may be frisked for weapons, pat down, frisked, whatever, under the following circumstances. First of all, the suspect has to be lawfully detained, right? Lawfully detained. All right. So the person, you have to reasonably believe that hold on one second. You have to reasonably believe that the suspect is armed or dangerous. Now, okay, let's back up. The Supreme Court in 1967, okay, with Terry versus Ohio, they used the phrase armed and dangerous. Armed and dangerous. A better way of actually articulating that and or at least thinking about it is armed or dangerous. Okay? Armed or dangerous. That 1960s talk, armed or dangerous, is from Hollywood. Okay? You can imagine it, right? Anyone armed, that's right. So but somebody dangerous may not be armed. But the point here is that it's just Hollywood talk, you know, be on the lookout for somebody, you know, armed and dangerous. But it could also be just dangerous. For example, the person has fighting skills, right? They tell you that they're a mixed martial artist and they're, you know, there's the huge size differential, right? We have a small stature, you know, versus somebody who's big and, you know, 250 pounds, all muscle. You're going to have more reason to pat that person down because if you did get into an altercation, that any kind of weapon is even more going to make it right. Cauliflower ears, actually, it's true, right? Cauliflower ears and so forth. So what I'm trying to say to you is that if you can articulate that the person is dangerous, a gang member, right? They're fighters. One of the things that the court will allow you to do is try to even the playing field a little bit. Okay, even if you know that a mano to a mano, you can't take this person out. You're going to have to use some tools. But we definitely want to get rid of, if they have some kind of blunt objects, knives and so forth, we want to get that off their person. Okay, so that's what we're looking for. Now, we're looking to articulate armed and dangerous. Enter this book. Hold on. This is the New Testament. The New Testament. I crack myself up. Okay. So I show you and I describe how to articulate armed and dangerous on page 224. All right. Actually. Okay. So first of all, just like Nitin says, no, Nitin, do me a favor, resend it out to all attendees. Nitin, it's nice to have you here, buddy. Okay. Nitin is giving us some good advice. conduct, gesture, behavior, totality of the circumstances. That's the standard here. Okay. So here is how I describe it in my book. Okay. I got a lot of things. So I'm going to spend some time on this if you don't mind, guys. Okay. If you have more questions. That's awesome, Emily. Okay. So, all right. So here is what I talk about in the book. Pre-contact considerations. Okay. What did you know before you even stopped out this person? High crime area. Explain why. You can't just throw high crime area out there. But guess what I have also in this book? Articulating high crime area. So late at night, weapons in plain view, right? Backup would take a while to arrive. The officer is on plain clothes, right? He's in plain clothes and doesn't have typical, less lethal tools. That is going to give you more reason to be extra cautious. Because if shit hits the fan, you don't want to have to shoot some guy that could have been handled with a non-lethal tool. One hand is open palm, right? Prepared to grab a gun, and the other, and another one's like near his shirt. These are just things about pre-contact. Okay, now we talk about the reason for detention. These are all categories in this book, okay? Weapons were involved. The stop was for a sexual assault, drive-by shooting, drug dealing, and so forth, right? Burglary. From training experience, they need pry tools. They need to make forced entry. Those pry tools are now a weapon of opportunity, okay? Then we go into concealed carry indicators, firearm printing. The suspect unconsciously is adjusting the waistband. Hands keep covering a certain place. He's trying to cover the firearm bulge and so forth, right? He has a short stride on one side. I'm not going to go over every single thing. There's like 100 things in here, right? Gun-related clothing, gun-related stickers on the car, open jacket in winter, closed jacket in the summer. Suspect's attitude, fight or flight behavior. He appears under the influence of narcotics, which reduces inhibitions. Suffering from a dangerous mental condition. Suspect clothing, bulky, consistent with the concealed weapons. Physical characteristics, officer size ratio. Questions, he admits to violent prior acts. Records check, he has a history of violence, history of selling narcotics. He has a concealed weapons permit. Man, Adam, furtive movements is another one, right? Abnormal nervousness is another one. Again, under the influence, active drug user is another one. That's how you do it. That's the name of the game. Yeah, that's right. So, in fact, Nitin has been, Nitin, you have how many years of experience? You're with the New Jersey DEA right now. How many, don't you have like 38 years of experience? I'm going to ask you a question because I think you have like 38, something like, I know it's a lot of years. Okay. Yeah. Nitin is legit. Okay. So Nitin, I'm going to bounce something off you. I'm going to give you my opinion and you tell me if you agree with it, yes or no. Okay. There you go. Yeah. Nitin's with New York, New Jersey HIDA. There we go. So almost 40 years. Okay. And he looks every bit of it. So, all right, AJ, see you next time, brother. Okay. So, suppression hearings. I want to talk about suppression hearings. Okay. True or false? 99% of the time, suppression hearings are determined by the report. In other words, a shitty report means suppression hearing. A solid report, 99% of the time, means no suppression hearing. Do you agree with that statement? Yes or no? True or false? And other people can. Yep. Right. And grand jury testimony. Yep. And here's why. Okay. First of all, most of you guys hate suppression hearings. First of all, you guys hate going to court. You're all good and it's all fun and games when you're the one interrogating somebody, and then you're like, you're on the stand. You're like, yeah, well, or it's like when you get hit with an IA, right? Now you're being investigated. It's like, how you like how it feels? You know what I mean? You've been doing it for your whole career. You've been investigating other people. you sleep well at night, and then you get that letter that says you're being investigated. It sucks, right? Okay, so, all right. So, wait, you're saying you've only been investigated IAs 3 times in your career? Is that what you're saying, Nitin? Only three times in your career? Oh, suppression hearings. I was going to say, if you only got 3 IAs in your career, you weren't working, dude. Not in New Jersey. Not in New Jersey. Yes, you got 1 for every year, dude. Man, I almost lost mad respect for you. I mean, you better come with some IAs, man, before you have some street cred with me. All right. So, but there it is. Okay, there it is. Actually, there's 2 things that I really respect about an officer's career. These are the 2 factors, right? Statute of limitations best. One is when they don't have a lot of suppression hearings. It's true, because that tells me that they write really good reports. If you have a lot of suppression hearings, and again, you can't be responsible for somebody else's report. So if the suppression hearing is really over a supplement from your partner, you have no control over that. You're gonna have to go. But if you don't have a lot of suppression hearings, and also, you're not getting sued a lot, that means that your report is solid. It's answering the questions that need to be answered at the report level. Okay? The other thing I really respect is when officers have a relatively low amount of use of force, because that is a very good indicator. I'm not saying it's always true. It depends on your environment and, LA versus, rural Texas. But it does indicate to me that if you have relatively lower use of forces and you are working a lot, you can talk to people. So you have a gift of gab, because many times you can talk people out of using force on them. That's my personal opinion. If you share it, great. If you don't, no, reason lines can differ. But that's my point here, is that those are indicators. But as far as the legal issues here, and here's why. This is why this 99% of the time, suppression hearings are handled at the report level. A suspect does not have an automatic, I should say defendant. A defendant does not have an automatic right to a suppression hearing. They don't. Their lawyer has to argue before the court why they think they deserve a suppression hearing. And that comes from the use of the reports. So the defense attorney will read the report and say, look, there's something missing here. If what the officer said happened, we have a problem, because that's a constitutional violation. There's a suppression issue here. But if the report is so ironclad and airtight, there is no suppression hearing, because they can't prove it. Now, the defendant has an absolute right to a trial, but not to a suppression hearing. They have to meet a burden of proof first. Okay. Maybe I overkilled that question. Probably not, though. That's what you wanted to hear. It's all about articulation. And there's various factors. Okay. Again, I have like 12 different factors. Good. 12 different factors in this book that I want you to articulate, to at least look at. And one more thing, since I'm on my high horse, right? Since I'm on my high horse, I also want to share one more thing with you. And every officer, not just you, but every officer should also know this. It's called, it has to do with the objective officer standard. So when you're on scene and you're trying, you're on scene, you take care of business, you pat somebody down, you find whatever, and then you're back at the station and you're thinking about how to write your report. Okay. And you start looking in this book and you're like, you know what? That guy was doing that. I didn't think about anything of it, but I did see that guy doing that. And I'm telling you that it's part of reasonable suspicion. It's one more factor that leads a reasonable officer to believe that it was suspicious, or the person had a weapon, and so forth, narcotics activity, whatever it is. Okay. Now, my question is even though you did not realize it on scene, in other words, that wasn't part of your math, the reasonable suspicion math or the probable cause math, However, if you now view it that way based off this book while you're writing your report, can you add it to your report? Yes or no? Okay. The answer is yes. But it's not, but Brian, here's the problem. Okay. Here's the problem with that whole about working backward. Now, first of all, you have to have probable cause or reasonable suspicion, but the legal standard is not what you personally thought on scene. Frankly, if I can just be, we don't really, the court does not, I mean, they care, but not legally care. We don't care about what an officer really thought. What we care for criminal investigations, okay? Criminal investigations. Community caretaking is a little different. But criminal investigations, what we care about is what would a reasonable officer have believed. Totality of circumstances. Now, one thing, Brian, we're going to be on the same page, okay? We're going to be on the same page. Here's the one thing you got to be careful about with this logic. If you were unaware of the issue on scene, you can't do it. Does that make sense? But that wouldn't apply here, because if you saw it and you knew it, it's like, oh man, I didn't even think about it. Right? I didn't think about it that way. But Anthony, in his book and so forth, but that's good. That's the objective officer standard. But if you look at your camera, okay? If you look at your body-worn camera and it shows something happening on scene, but you were not aware of it, you cannot use that in your report. Does that make sense? That is working backwards, like Brian is talking about. And that is creating something that wasn't there on scene. You can only translate things into reasonable suspicion and probable cause that you knew about on scene. Therefore, that gets inputted into the objective reasonableness computer, you might say. Does that help? Yes or no? Okay, good. Kind of interesting too. And by the way, it's saved a lot of cases. It has saved a lot of cases. Yep. A lot of cases where the courts are telling, hey, officer, your report is really not that great. But because we use the objective standard, you're going to be fine, because there were other things in there that I know contributed to your PC. But if based off of complete your report alone, that wouldn't work. A good case, by the way, is US v. Richmond, 5th Circuit, 2018. Is a good case about that. All right. Anything else before we end off here? Any other questions I can answer for you? I mean, I had something preloaded, but I think we had a good talk. And, I want to keep these kind of short and sweet. I'm working on some client issues, so I don't want to drag it out, but I do want to, answer your questions. Cool. All right, John, thank you, Emily. Guys, God bless all of you. God bless all of you. We moved the ball forward, right? We moved the ball forward. Please come back next week and share the love, man. Share the love. Let's get more officers on here, okay? Let's get more officers on here. Thank you. All right, guys. And hopefully I'll see you in a full day class, either live or on demand. On demand. Yep. I sure do, Adam. Hold on. There you go. Hey, William. William, where do you work at? Are you Las Vegas Metro? No, you're not Las Vegas Metro, are you? No. Your name looks very familiar. All right. You're welcome, Adam. Thanks, Walter. Hey, Nitin, man, dude, I know it's been crazy. Thank you. for showing up. It's been a while since I've seen you. I missed you, brother. Oh, Idolest. Yes, of course. Idolest. Yeah, that's great. That's great. I knew your name, and I was mixing up with somebody at Metro. So cool. It's good to have you here, buddy. It's good to have you here. So for everybody, Idolest is a great resource, man. They also certified national instructors. So if you are a trainer and you have, credentials and you have been doing this for a while, you should reach out to Idolest and get certified as a national certified instructor, NCI. That's a good program. Yep. All right, guys. See you. Learn some webinars this week, and if not, I'll see you guys next week, Saturday. See you guys.